Good morning and welcome to the First District Court of Appeals. We have several cases on our docket this morning. Two are set for argument. The first case to be argued is Collette versus Sharkey. Ms. Salyer is here on behalf of appellee. Mr. Wyatt is here on behalf of appellant. Mr. Wyatt, would you like to reserve any of your 15 minutes for rebuttal this morning?
5 minutes, please.
All right, and whenever you're ready, you may begin and I will keep your time.
Thank you. May it please the court, we are here today regarding a serious injury sustained by the appellant when she slipped and fell on water. I think it's important to discuss briefly why she was at the home at the time of the fall, because that goes to her classification and the duties owed to her. Prior to the fall, Ms. Collette was tending to Mr. Defendant or Appellant Sharkey's uncle, Tim Sharkey. Unfortunately, he had fallen ill and ultimately passed away from his illnesses. After his death, the home passed to Defendant Appellee, Mr. Robert Sharkey. The morning of the fall, Ms. Collette entered the home using a key, and it was attempting to help clean a little bit and remove some personal belongings. The parties have essentially agreed that this made her a social guest. In the Ohio Supreme Court case of Scheibel, the duties owed to a social guest was determined to be the duty to use ordinary care not to cause injury, and the duty to warn of known dangers that the guest does not know and will not be able to discover.
So is this a duty to warn case from your perspective?
It is not. It is actually the duty to not use ordinary care to cause injury to the plaintiff, I believe, is what actually this case amounts to. And
so if we change the facts slightly and the water was spilled before she arrived, she comes in the door and the appellee says, "Hey, watch out, there's some water I spilled there," and she nevertheless goes and slips on it. That's a different outcome in your view?
I think if that were the clear-cut facts of this case, then summary judgment would be appropriate in this case. I do.
Okay, so then let's help me understand how that's different. And I realize there's a timing issue, but if at the end of the day, your client had the time and ability to recognize the water was spilled and to affirmatively comment on that, how is that different?
I think that's different, and it can be addressed in a couple of different ways. Specifically in the Simmons case of the 10th District, it specifically looks at whether or not the active conduct on behalf of the defendant was the cause of the injury. And so if, as there are some facts in this case regarding the timing show, specifically that the fall happened within seconds or moments from the time the water was spilled, that the water was spilled in such close proximity to the plaintiff appellant that it probably spilled on her, and that even Mr. Sharkey himself testified that he didn't even have the opportunity to place the ice maker down before the fall happened. The Simmons court specifically said that it was a genuine issue of material fact on the timing, and that reasonable minds could conclude that the act of, which would be in our case, spilling the water, was the cause of the fall. Also in the Asher First District case that was cited, the determination was made there that even though the hazard was observed with the doors opening outwards, knocking the plaintiff in that case backwards off of the top step, that by the time that she had encountered the door opening, by the time she had discovered that, she was also already encountering it. And that goes to the second part of the open and obvious doctrine that specifically states that the owner may reasonably expect the person's not entering the property to discover the danger, but also to be able to take appropriate measures to protect themselves.
So I guess I'm sorry, go ahead, Judge Bergeron.
No, Judge Bergeron, go ahead.
Well, what's the evidence in the record that if she saw it and was cognizant of it, that she was not able to take protective measures to avoid the fall?
I think that just purely the timing of the fall. The fact that I believe Miss Winters stated that it happened almost instantaneously, the fall. In order for that to happen almost instantaneously, there must have been nothing else she could have done in order to avoid stepping in the water, which ultimately caused her to lose her balance and fall.
Mr. Wyatt, go ahead, Judge Myers.
Didn't your client testify that it was much longer than that?
Her testimony, frankly, was all over the place on the timing of it. I think at one point in time, it was a couple of minutes. Another time it may have been longer. Again, I believe that this testimony is no different than Mr. Sharkey's testimony of saying that it happened so quickly he couldn't even place it down, place the ice maker back down. Again, I think that goes to show that there is a genuine issue of material fact on the timing of the fall, and that is a material issue that I think should be one for the jury to deal with, who they believe was more accurate in the timing of what happened that day.
Does the timing matter if it's undisputed that she is the one who noticed it and brought it to everyone's attention, among other people?
Yes, I think the Asher court says that it does matter, because the Asher court, the first district stated in Asher that discovering that she did discover the hazard, the plaintiff in that case, but at the time she had discovered it, she had already encountered it, and therefore open and obvious didn't apply to it. Again, I think that the facts of Simmons are important in this case, again, because it specifically distinguishes two types of negligence: the passive negligence, which is created by a static condition that had pre-existed, and active negligence created by the actions of the defendant. This court has addressed Simmons in the Korngal versus the Little Miami Golf Club case. In that case, this court had declined to apply Simmons, but did not indicate that they had any objections to Simmons' holdings. Simply, this court discussed that the facts were too dissimilar, mainly that the hazard in this case was a dead or dying tree that ultimately caused injury to the plaintiff when a limb fell through the blowing of wind, which was not the act of an individual. So this court specifically has decided that while Simmons may apply in other situations, it didn't apply to that one. Our case here today is much similar to the Simmons case in that the actions of Mr. Sharkey reasonable minds could conclude that the actions of Mr. Sharkey caused water to be spilled into the path of plaintiff, that she had no time to react, to avoid falling, and that when she fell, it was the result of the direct actions of the defendant and not because of a passive static condition that had existed for long periods of time.
Was there evidence that she was in the midst of walking when the spill occurred and when she fell?
I don't think that there is a specific testimony that what she was doing at the time the water was spilled. At least there wasn't specific testimony indicating that she was walking at the time. However, in order for her to have fallen within the amount of time that at least some of the testimony indicates, she must have been either walking at the time, or, as again the Asher court would indicate, that she was in a situation where she had already encountered the danger and that there was nothing that she could do to avoid it. I think ultimately that's the gist of the argument completely, is that the trial court, I do not believe that the trial court analyzed the issue of the duty of active negligence on behalf of the defendant. Unfortunately, there's not a written entry or opinion as to what specifically the court discussed, but it is clear that they focus solely on the open and obvious doctrine based on the transcript of the oral argument. I believe that that viewing the facts in the light most favorable to the plaintiff, reasonable minds could conclude that the direct actions of Mr. Sharkey were the cause of Miss Collett's fall, thus breaching his duty to not cause injury to his social guest. Because of that, we believe that this court should reverse and remand the trial court's decision to grant summary judgment.
Thank you, Mr. Wyatt, and you are at your time. You will have 5 minutes remaining. Ms. Salyer, you have 15 minutes.
Thank you, Your Honor. May it please the court. I'd like to just jump right into the issue of timing, if that's okay.
Yeah, and maybe if I could push you a little bit on that, and let's assume a slightly different factual scenario in which she does not see and comment on the water being spilled. So she's like walking behind your client, the water spilled, she doesn't see it, and everyone agrees she doesn't see it, and she fell. Would you agree with me that that scenario would be inappropriate for summary judgment on those facts?
On an open and obvious basis, yes. There could be the argument that there wasn't time to clean up the spill before she fell in it. That would be a separate issue. But with regard to timing, yes. But in this case, there are 3 people in the room, and all 3 people agree that she saw the water spill. She gave the warning. And when she gave the warning, she used past tense. You spilled water. So she saw it spill. She gave a warning that the water spilled. The warning was acknowledged. And then she fell in it. Whether she fell in it 1 to 2 minutes later, several minutes to 10 minutes later, or moments after that happened, really is not as relevant as the fact that she saw it spill. She said it spilled in past tense, and then, her warning was acknowledged, and then she walked into it and fell.
So your theory is almost like a last clear chance or something, that the plaintiff was cognizant of the hazard, had the opportunity to avoid it, and then nevertheless did not avoid it. Is that fair or close?
It is. I mean, that it's really what is the open and obvious doctrine. In most cases where we're arguing open and obvious, it's was the condition observable, not whether the person actually saw it, but whether they could have seen it. Because usually if the person admits they saw the danger, we're not here arguing about it. That's a clear, open and obvious. That's what open and obvious is. If you could have seen it, could have appreciated the danger, then it's open and obvious. Here she acknowledges and admits that she saw it, and she gave a warning to other people about it. So she acknowledged that there was a danger in it. And then after that, she walked right into it. By her testimony, she was sitting at the table and walked forward toward the sink. And that's when she slipped. So
Wait,
by her
I'm
own
sorry. She was sitting at the table when the spill occurred?
She didn't say exactly that. She said that the water was spilled. And then the question was, then what happened? And she said, I sat at the table. I went to put something in the sink, put it in the sink, turned around. And when she was walking back from the sink was when she slipped. But she did use the words that she was sitting at the table. She walked through the spill to the sink. And when she turned around, she took a couple steps and heard the squeaking of her flip-flops on the linoleum, took 2 steps with the squeaking, and then slipped and fell. So by her own testimony, it was not, that the water was spilled right into her pathway as her feet were going down. She had time to see it, appreciate it, take steps, hear the squeaking, and then go down. So I'd like to then also acknowledge the cases raised by the appellant. The Simmons case, the danger would have been open and obvious if the person if it had not been covered with a protective cover. And the plaintiff saw and knew that the danger was covered. While the plaintiff's back was to the danger, that cover was removed, and then he was walking backwards out of a truck and stepped into the gap. So the thing there was the court said he wasn't able to appreciate the danger because the condition changed while his back was turned. Somebody came and removed that when he was unaware, so he couldn't appreciate the danger. Here, the condition did not change after she realized it. She knew that there was a danger of water, and that danger never changed before she slipped in it. So it's really not the same thing. The other thing in Simmons, you could say it would be analogous if the person in the truck walking backwards, if he had said, oh, look, someone removed the cover, then you would say, well, it was open and obvious to him, because that's what happened here. She saw the danger and pointed it out. So Simmons in this case are different because in Simmons, the plaintiff could not appreciate the danger and the danger changed. Here it's different. Similarly, the Asher case, that's when the door opened out over the landing at the top of the steps. And the court found that you wouldn't know that the door is going to swing that wide and force you backwards down the steps until it's actually swinging open. And so the danger is not encountered until the door is actually swinging at you, forcing you back down the steps. So the danger isn't encountered until right then. Here, again, she was well aware of the danger. She spoke about it, that it already happened in past tense, and then she walked forward and slipped in it. So it's really not the same thing. And again, if she had,
would the situation be any different if, let's say, it was spilled in one corner of the kitchen and it looked like it was just a small spill, and then people weren't paying attention, and because the floor wasn't level, the water migrated, and then she walked in an area that wasn't the direct location of the spill? Would that change the analysis at all?
well, it could. Again, it would raise the question of, was there time to clean it up before she fell in it? But once somebody is aware of the water spilling and is aware that the floor is wet, there would be some duty on her to know that there is a wet floor here. I think that could change, and you could say, well, there's a question of fact for the jury then to decide how much time passed, how much water spilled that it was able to travel across the floor. But in this case, it went directly down onto a kitchen mat that was in front of the sink. So it was pretty much contained on that mat. She just happened to step right in it when she went to the sink, right where she saw it being spilled. So I think when you talk about an open and obvious danger, that is open and obvious to her. It wasn't, I don't think it's really an issue of static versus dynamic, or a known or unknown condition, because the water wasn't changing. That's not been alleged. And the condition did not change after she realized that the water had spilled. The water was there, nothing happened to change it. She walked into it and she fell. And everybody agrees that that's what happened. There is no disputed fact that a pellet Sharkey was picking up the ice machine, that the water spilled, that she said it spilled. They all agree that they were aware that it spilled, that the warning was acknowledged. And then right after that, she stepped there and fell. So when you talk about what is the quintessential open and obvious case, I would say it's when the plaintiff themselves sees a danger, points it out, and then walks right into it. That's when you say, well, that was open and obvious to them. So I just argue that the trial court did properly grant summary judgment based on the open and obvious doctrine, and I would ask that the court uphold that judgment. I yield the remainder of my time unless there are any further questions.
Thank you very much. Mr. Wyatt, you have 5 minutes remaining.
Thank you. I just wanted to quickly touch on a couple of different points. The first in regards to the analysis of the Simmons case. If we look at the facts of that case compared to the circumstances that we have in our current case, a dock plate was removed from the back of a truck to a warehouse. The amount of time in which happened that would take for that plate to be removed, and something removed and moved, and the amount of time that would have happened compared to how quickly testimony indicates that water was spilled here, shows that it's possible that even more time could potentially pass between the act of, in the Simmons case, negligently removing the plate, in our case, the act of spilling the water, and the actual injury.
Counsel, can you please address the difference though between, in that case, the plaintiff didn't see the danger. In this case, she did. So even though there might be a time comparison, there still is the fact that she saw it, and in the other case, he didn't.
Sure. As counsel indicated earlier, the open and obvious doctrine actually doesn't even take into consideration whether you saw the hazard or not. And in the testimony of the Simmons case, the plaintiff specifically said that had he been looking, he should have seen it. And so I think that it goes back to the Asher decision, and a word that keeps being used is that the plaintiff appreciated the danger. I think that is an important word, and that appreciate, because appreciate means more than just witnessing something. It also means the ability to understand the significance of it. And in such a short period of time, even if a person knows that water is slick and water can cause a fall, there is a period of time in which you are unable to fully appreciate that water is spilled in my path and it will cause me to fall, if it was in fact seconds, as at least some testimony indicates. I made this analogy in our briefing that I can observe a car running a red light and not do anything to avoid that car from hitting me. Now, that's certainly a different circumstances, but the premise is the same. There is a difference between—
Well, wait a minute, but in your example, if the car is barreling towards you and you don't have time to react, that's different than if you say, oh my gosh, a car is coming at me, and then you take 5 steps into its path.
Correct. And I completely agree. And our position today is not that the open and obvious doctrine can never be applied to the facts of this case. The argument is that the open and obvious doctrine cannot be applied to the facts of this case at this time, because reasonable minds can conclude that the timing that took place between the spill of the water and the fall was enough to make this active dynamic negligence on behalf of the defendant, and not a passive static pre-existing condition. Again, without further questions, it's our position that the summary judgment was improperly granted, and that the open and obvious doctrine was improperly applied at this stage of the case, and that we ask this court to reverse and remand the decision.
Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion. Thank you both. And Ms. Hayden, if you will let our next litigants and counsel into the courtroom.
Thank you.
Thank you, Your Honor.
Good morning. The next case on our docket this morning is State versus Stoneage. Mr. Cohen is here on behalf of appellant. Mr. Satter is here on behalf of appellee. Mr. Cohen, you will have 15 minutes to argue. Would you like to reserve any time in rebuttal this morning?
I'd reserve 3 minutes.
All right, and whenever you're ready, you may proceed.
Your Honor, I have a question for the panel. A decision was rendered in this case and published on Friday. I'm not sure if that becomes the law of the case. It's the first time I've had this appear. It was a unified motion to suppress. The actual motion to suppress and memorandum were prepared by both counsel, filed separately to keep things clear. Single hearing, single judgment of the court.
Mr. Cohen, what I think the panel would like you to do today is argue this as if the decision had not been released, and in the sense that if there's something you want to focus on in that opinion, please do so. Mr. Sauter, same for you, but you will get your full argument time today, both of you.
Outstanding. May it please the court, Mr. Souter. Sorry, it's strange doing an argument while sitting down, but nonetheless, court, I presume, is familiar with the briefs on both sides. I'll try and keep it brief, so to speak. Lawyers have trouble doing that sometimes. So maybe to make it simpler, I will start with the court's dissent in the decision. What we have here is a case where Mr. Stoneage was arrested after a fairly lengthy investigation in January of 2017. The investigation revealed what appeared to be a substantial drug trafficking operation. Arrest was made in January 17. The matter resolved with a plea in September of 17, at which time Mr. Stoneage pled to a misdemeanor. My argument with the police officer's search warrant is that that search warrant contained information that was at the best 17 months old. And it also neglected to advise the reviewing court that that matter had resolved in a plea to a misdemeanor. Now, plea to misdemeanor conduct should have been a signal to the judge that there was something amiss with that case. You typically do not go from drug trafficking following a lengthy investigation to a misdemeanor unless there's a problem there. Now, this is not in evidence, but I do have personal knowledge of the case. The case in Jones involved an individual who made a phone call to the police for somebody who would refuse to leave a residence. That residence was visited by law enforcement. The individual that had remained in the residence was known as a meth manufacturer, a lab tech for better, lack of a better term. A number of years later, information came to light that an individual, not Ms. Jones, but somebody else, had run a substantial meth manufacture operation. They observed Ms. Jones with Ms. Chappell, came up with some other information about Ms. Chappell from a number of confidential informants, including that Ms. Chappell had moved her methamphetamine operation to Raleigh Avenue, which was the location of the burglary where law enforcement first met Ms. Jones. So they have a substantial amount of information related to that address. The distinction here is we have now an address where law enforcement, 17 months after.
So, Mr. Cohen, could I interrupt you
Sure.
on the misdemeanor felony question? I'm looking at the affidavit, and it's in paragraph 34 of it says a BCI search of Jacob Stoneage revealed felony trafficking in drugs and possession of drugs. Stoneage was convicted of attempted trafficking in marijuana in February of 18. So are you suggesting that that is inaccurate?
Well, it doesn't say that it was a misdemeanor.
So you're saying the 2018 conviction was a misdemeanor?
Yes. And that came out.
What was the felony reference in the middle of that paragraph?
It was charged as, it was indicted as a felony, but the case was resolved as a misdemeanor.
So are you suggesting then that it's misleading to tell the judge they were charged with felony and were convicted, but not to clarify that they were convicted on a misdemeanor?
I think it's crucial. I mean, you appear in room A in this county and city of Cincinnati or surrounding areas with a pretrial services report, which shows a number of charges, sometimes from out of state. My favorite was the murder charge, no disposition. I had to call the sheriff in Los Angeles to find out that they round up a bunch of people when there's a gangland shooting and they charge everybody with murder and then it just disappears. So BCI does not necessarily show the resolution of the case as far as the specifics. NCIC, the National Crime Reporting System, would do that. So I believe that, in a sense, was somewhat misleading, but we're really looking at in this case, the staleness of the information. In the evaluation of the court's opinion that was published Friday, the dissent referred to a 2008 case from the 12th District. I'm on the record here, I don't want to say too much about the 12th District, but I do not think anything out of that district should be controlling in the 1st District for a number of reasons. But that was a 2008 case involving a single trash pull. Jones was decided in 2015. That's a Supreme Court case, which is controlling in this case. The surveillance on this case, I don't even think you can call it surveillance. Law enforcement received a notice from Butler County. They called the burn unit, their task force, contacted them, advised them that Mr. Stoneage had moved to Coleraine Township. So they drive by the location, they verify that somebody's living there. They come back on another day.
Could you also address the time lag between when the officer did the trash pull and when the ultimate search was? Because I think your argument on that was a little bit different or more developed than the argument in Martin.
Essentially, they did the trash pull. Get my dates here, I apologize. There was approximately 5 days in between the trash pull and the execution of the warrant. So there was a lag based on the weekend when they got the warrant. It was on a Thursday. So you got Friday, Saturday, Sunday, executed on Monday, I believe. So we have that. But what's more importantly, if we're going back to the trash pull, this is a curtilage issue. And what is curtilage? The cans were not on the street. I mean, the law is established. You put a can out on the street, you're free to look in that can. In this instance, the officer indicated the can was not on the street. It was not a trash day. He doesn't know when the trash day was. He doesn't even know when the trash was put in the trash. It could have been the day of the trash pull. It could have been several days before. So there's no way to establish when that trash was recovered. So we're really trying to guess, and the officer could provide no useful information in his testimony, the answer to any of those questions. All just basically saying he had no knowledge, he had no knowledge, he had no knowledge, multiple requests for information regarding how, when, and who pulled the evidence. Going back to when Judge Scalia was in the Supreme Court, case of Florida versus Jardine, which kind of started a little bit of this kind of revival of trespass in order to get information. They would have had to go on the premises, look in the can. We understand that a driveway or a sidewalk to the front door is, in a sense, an invitation. The law enforcement's not invited to wander around the property looking in closed containers. The case law allows, officer comes on the scene, looks in and sees something. That's different. There's no testimony that they did. They said they pulled it from a trash can.
Are you suggesting that there was an improper trespass?
I am, although that case law is not established. As I said, going back to Jardine essentially revived some of the trespass. We went from private property to a privacy interest in Katz, followed by Jardine, Florida versus Jardine, where they, does a person have an expectation of privacy on their property? I think this was a violation, but in any event, I don't think that's well-established law. I think this court has the authority to give that consideration. I think the court has the authority to provide more deference to privacy interests in the federal Constitution. But in this instance, there were no tips. There was no confidential informant. there was a single trash pull with no current information. We have Leon. Leon is a wonderful case and a horrible case. It's a wonderful case because it establishes steps to look at whether or not there's a proper search warrant granted. And in this instance, or let me back up. The downside of Leon is it allows almost every single challenge to a search warrant to be upheld because of good faith. And that was not the intention of the Supreme Court. It set out 4 factors they should look at. In this instance, it's presumed that a neutral and detached, using those words advisedly, a neutral and detached magistrate, or in this case, a municipal court judge, knows the law. And the law says that a single trash pull is not sufficient without something else. The search warrant was for a place to be searched. In Jones, they had information that that location was for methamphetamine manufacture. They substantiated with a trash pull the chemicals related to methamphetamine manufacture. This was search warrant for a residence, not an arrest warrant. This residence, there was no information, not confidential, not law enforcement, not surveillance, which indicated the house was being used for any purpose other than somebody living there. They single trash pull, they find plastic bags. The Senate referenced plastic bags with stamps on them identifying a product. These were plain plastic bags. They were never introduced as evidence because apparently they weren't retained.
Mr. Cohen, you are at your time if you'd like to reserve 3 minutes, but I will let you finish that thought that you were in the middle of.
So essentially, we have no corroboration of the information obtained from what I would consider an illegal trash pull. Thank you.
All right, thank you. You will have 3 minutes remaining. Mr. Sauter, you have 15 minutes.
You're on mute, Mr. Sauer.
Happens all the time. Sorry about that. May it please the court, Mr. Cohen. Judges, I have just a few comments to make about some of the arguments that Mr. Cohen made. First of all, as to the case being reduced to a misdemeanor, I don't think that appreciably alters the equation of what the municipal judge had to look at when it.
Well, let me ask you this. First of all, do you agree that it was a misdemeanor conviction?
I absolutely agree. Yes.
Okay. And then I guess my next question is, reading that last paragraph of the affidavit, do you believe it's misleading to indicate that he was under felony investigation and then convicted without clarifying that it was a misdemeanor conviction?
Well, these cases are, I think it was, I think it's not, maybe the information wasn't complete, but it's definitely not, I don't think it's misleading. Cases are pled down for many reasons all the time. The indication in the affidavit was that it was a felony investigation that was pled out to an attempt. So there was at least an indication that it wasn't pled as charged. There was a reduction in the charges. And I don't know that the distinction between a felony and a misdemeanor makes a lot of difference in the equation of whether drug activity was occurring at that residence at that time, and whether it's corroborative of drug activity occurring at the residence in Hamilton County.
Well, I mean, if you think this guy is a drug kingpin, then that might influence what the lens through which you view the trash pull evidence.
I would agree with that, Judge. I apologize. I didn't mean to talk over you. No, I agree with that. But the tenor of the affidavit wasn't that he was a kingpin. It was a fact-based recitation of what the police knew had occurred in Butler County, and I don't think there was any attempt to exaggerate the importance or the level of activity that had occurred in Butler County. As for the Jardine case and the legality of the trash pull, I think I don't think that is. First of all, I don't think it's been preserved, because I think that it's it was essentially conceded and not raised on appeal that the trash pull was proper. curtilage or not curtilage, there was no indication of illegality on the part of the police officers. And I think that in any event, that went to the presence or absence of probable cause and did not directly relate to the good faith exception established in Leon. I can't say it any better than the dissent said it in this case. I think that when the court looks at when you look at the evidence in isolation, what happened in Butler County and what's alleged to have happened in Hamilton County, I agree that it doesn't look strong. But when you combine the two, as we are told to do in Jones and its progeny, well, and Leon and Wilmoth and Hampton from this court.
But I want to press you on that. I mean, what is the link, other than these are the same people? What is the link between the evidence of the Butler County investigation and what they saw in the trash? Because as I read the officer's affidavit, he says that it is largely consistent with personal consumption. And he acknowledged on the stand that it was consistent with personal consumption. So where is the trafficking indicia that links to what happened in Butler County?
Well, I think it's hard to overstate the fact that these are the same people, and that the fact of the location of the residence is, while important, is not the be all and end all of the inquiry. And I think that the indication, as noted in the dissent, that these large containers that were inconsistent with personal use, they had a strong odor of marijuana about them, was an indicia of trafficking as opposed to personal use.
And you mean the bags?
The baggies, correct? Yes, Your Honor.
But so the problem with that, and I mean, obviously, you know what position I have in Martin, but the problem with that is there's no real elaboration on the quantity, the size of those bags, or any sort of like, hey, these are the exact same brand bags that were used in Butler County or something like that. I mean, don't you need something more than that?
Well, it's always as noted in the dissent and the majority in Martin, there's always more that the police could do. But in terms of the narrow question of whether the police had a good faith reliance on the warrant in this case, I think that the size of the baggies and the smell of marijuana was a sufficient indicia of probable cause to at least permit the police to rely on a neutral judge's determination that it was more likely than not that there would be contraband found in this house. And as we know, probable cause is a term that's hard to define, but it's never been. It's always been a standard that's far less than beyond a reasonable doubt. And I think that under the facts of this case, you can say that it would be more likely than not that contraband would be found in this house based upon the knowledge of the Butler County investigation and what was found in the trash bowl.
Can you clarify something for me? I think I remember this, but the officers, there was no testing of anything that came out of the trash bowl, correct?
That's correct.
Including what was inside the bags, if anything was inside the bags?
That's correct.
Thank
there
you.
was residue, and it was consistent with, and the odor of marijuana was characterized, I believe, as strong. So there was some indicia of a large amount of contraband being found in the trash bowl, but there was no scientific testing to determine that it was the drug. Beyond that, I would just ask the court to focus on the fact that there are two separate components to the equation here: the Butler County evidence and the evidence of the trash bowl. And I would suggest that the affidavit was not so lacking in indicia of probable cause that a reasonable officer could not rely on it. I would ask the court to reverse the judgment, or to affirm the judgment of the trial court. I have nothing further unless the panel has questions.
Questions? Mr. Cohen, you have 3 minutes. And you're on mute.
I was hitting the symbol, not the mute button. I apologize. All right, make it quick. Question was asked earlier, had time to take a look at it. The trash pull was on June 19th of 18, and the warrant was executed on June 26th. I attacked the search warrant on 2 bases, not just whether the officer was providing misinformation. I also was looking at using again that term, neutral and detached magistrate in terms of what the law is. I think the judge did not do the proper inquiry. I agree with Mr. Souter. We want police to do more. So I will remind the court that in the decisions regarding good faith in Leon, granting of a motion to suppress benefits a defendant, but that's tangential to its purpose. When a motion to suppress is granted, it's designed to school or teach law enforcement how to do their job more efficiently. The facts of this case, the police took a shortcut. They could have set up surveillance. They could have run an operation there. They could have sent people in, all the things they could have done. They didn't do that. They took 17-month-old information. They did one drive-by, picked up some trash, saw nothing else, got a search warrant. The way we make them better is we hold them to a higher standard, make them do their job. When they do their job right, there's no motion to suppress, there's no trial, there's a plea. So my argument is still the same. They're using stale information. They don't corroborate it with other than a single trash pull. I think it is on point with Jones, which says you need more. You got to look at the facts of Jones. You can't use the syllabus. You got to look at the facts of Jones and how much information they had on that address. This was a search warrant to search an address, not arrest my client, to search an address. What information did they have on that address? A single trash pull. Thank you.
Thank you both very much. We will take this case under advisement and give you a timely written opinion. That will conclude the arguments today in the First District Court of Appeals. Thank you very much.
Thank you, Your Honor.
Thanks, judges.